one cannot conclude that Mr. Leonard Modisa passes the test of being a reasonable, objective, and informed person because he was clearly misguided by Mr. Maluleke and the information contained in the very affidavit which forms the basis of his application. This is so because in his replying affidavit, he confirms that he agrees with Mr. Twala that Mr. Maluleke's affidavit was delivered in the context of Mr. Santlana's criminal proceedings. It is not clear when these criminal proceedings were instituted and how properly informed was Mr. Leonard Modisa when those facts became known to him, given the fact that the information was already in the media when he launched his application. It therefore follows that Mr. Leonard Modisa fails the test for recusal as applied by the Constitutional Court in the case of South African Human Rights Commission, that is stated supra. He also fails the test outlined in the case of Sarfu because he had already stated that he does not know whether what he was told by Mr. Maluleke is the truth, and acknowledges that the information is hearsay. Accordingly, the requirements that the apprehension of the reasonable person must be asserted in the light of the true facts has not been fulfilled. Furthermore, the court in Sarfu stated that the incorrect facts which were taken into account by the applicant must be ignored in applying the test. It therefore follows that the incorrect facts relating to the allegations of bribery cannot stand, as it becomes clear that the allegations were made in November 2021, when this case was not even allocated a judge or considered for case management, taking into account the concessions made by Mr. Leonard Modisa's counsel that the date of November 2021 does not tally with the date of 12 May 2022, when my registrar confirmed that I had just been allocated the matter to case manage, and also conceding that there are chronological problems and discrepancies. In the case of Zipeka versus DuPont Pioneer, the court stated that, open quote, time and time again, it has warned against litigants making unfounded allegations of bias on the part of the presiding officers tasked to decide disputes without cogent proof to substantiate the allegations. Any allegations of bias on the part of a judge must be substantiated by proper factual basis and must not be based on mere speculation and conjecture, and must be proved by a party alleging bias, close quote. In another case of Tinbull Jackson versus Hibiscus Coast Municipality, and another in open bracket eThekwini Municipality, amicus curiae, close bracket, the court held that, open quote, before I conclude, I am moved to caution against wanton, gratuitous allegations of bias, actual or perceived, against the public officials. Allegations of bias and antithesis of fairness are serious. If made with a sufficient degree of regularity, they have the potential to be deleterious to the confidence reposed by the public in the administrators. The reactive bias claim stems from the unconstitutional allegations, unsubstantiated allegations of corruption and incompetence. There are various allegations, especially the ones of corruption, and yes, if the public official is corrupt, they must be exposed for what they are, and unwelcome, cancerous scourge in the public administration. But accusations of corruption against an innocent may visit them with the most deliberating public abhorration. Gratuitous claim of bias, like the present, are deserving of the strongest possible criticism, close quote. The presumption exists that the judicial officers are impartial in adjudicating disputes. A fair and just legal system is founded upon the impartial adjudication of disputes that comes before the courts. An unfounded or unreasonable apprehension of bias is not justifiable basis for the recusal and the assessment of the bias, and it must be in the light of the true facts as they emerge during the hearing proceedings. And an incorrect facts must be ignored, and what is required of the judge is that they should decide the cases decided upon in the favor and according to the facts and the law, and not according to their subjective personal views. As alluded, Mr. Maluleke's affidavit spells out a very serious tension and animosity between himself and Mr. Sandlana, which this court fails to understand why this affidavit, which was already making rounds on the social media and which seems to be used or sneaked in through the back door as it relates to the issues to be decided by this court in the pending proceedings, considering what Mr. Maluleke stated, that being the fact that he has an in-depth knowledge of the truth relating to the claims of leadership of the church, considering the circumstances under which the application was brought, and the incorrect facts relied upon by Mr. Leonard Modise in his applications for recusal. Those incorrect facts must be ignored, and therefore inclined to agree with Mr. Epstein's submission that based upon the contents of Mr. Leonard Modise's founding affidavit, there is no basis upon which reasonably an objective or informed person or the court would conclude that there is a reasonable apprehension of bias. Consequently, there is absolutely no merit in the application that an apprehension of bias has been established, and in my view, there can be no reasonable person on the basis of the allegations who would have such apprehension of bias. I therefore find that no case has been made out for my recusal, and the application falls to be dismissed. In the case of Bernard Susan Hillary and another versus the state, the court stated the following, open quote, at paragraph 113, more and more recusal applications are brought as a tactical device or simply because the litigant does not like the outcome of an interim order and made during the course of the trial. A lack of discernment within which recusal applications are being launched or threatened is a cause for concern. The risk of recusal applications being used as a strategic tool is that far from securing the integrity of the court, continual foundation aspersions on judges may bring about the loss of faith in the judiciary as the whole and to bring it into disrepute. One would like to believe that where the judge's character is seriously impacted and clearly defamatory statements are made at a personal level, close quote. Now, at length, the short history of the court's case as it ensued between the parties and the state of affairs is regrettable. At this stage, I find it appropriate to indicate some of the concerns regarding how the proceedings have been conducted. It has become apparent throughout the proceedings that the respondents had been disadvantaged and not afforded the level of professionalism which one would have expected from an opponent as it relates to the preparation of their case. I found it unacceptable that the entire legal team of Mr. Leonard Modise did not find it meet and right to afford their opponents the courtesy of providing them with the proper documentation to prepare thoroughly for their case. As I indicated earlier in this judgment, the respondent had throughout the proceedings been kept in the dark, and this relates to the fact that time and time again, Mr. Epstein and his team would only be provided with documents minutes before the matter is called and placed on the record, while the court was in session regarding the application which the applicant would be presenting at that very moment. Mr. Epstein had, during his address on this application and during the previous application, asked the court to take note of how all the applications have been brought and how this specific allegations was brought, as the applicant have waited for more than 2 months to file his applying affidavit, only to do the same day, a day before the application was presented, and provided him with the heads of argument when counsel for the applicant stood up to address the court. I'm alive to the fact that the attitude of the applicant had clearly indicated a stubborn and misguided approach to the legal process that presents on a vexatious attitude. Regarding this application, what is rather concerning is that firstly, Mr. Leonard Modisa's legal team wrote an application by relying on the affidavit of a legal practitioner who has not only committed perjury, as Mr. Epstein has argued, but also brought the bench and the entire judiciary into disrepute. One would have expected Mr. Leonard Modisa's legal team to be meticulous in preparation of their case, rather than being ignorant and rely on the information of a legal practitioner who propagated an unfounded, dishonest, and untrue rumors which have brought the court and the administration of justice into disrepute, and which, in my view, requires full investigation by the relevant authorities, including the LPC. What is more concerning is that the entire legal team was fully aware of these allegations and the duration of their existence on social media, and none of them were brought to the attention of the DJP or myself before the 13th of February. Neither was the matter reported to the relevant authorities, which in this case would have been the JSC. It seems to me that the application was brought as an adjunct to the unsuccessful attempt to have the matter owned, firstly on the contrived basis that I had been a case manager, although no objection had been made or had been raised to that effect, and secondly, that after the leave to appeal was dismissed and the postponement was refused, then the timing and the manner in which this application was brought, coupled with the continuous threats that were made previously, had the consequence of making sure that the trial did not proceed for the 3 weeks which had been allocated. It also seems that whatever forces were at play were cynical in raising these spurious and unsubstantiated allegations, and one would have expected the applicant and his counsel to have known better than to place any stall on such allegations, but instead chose to be self-serving in a contrived manner to be deprecated to use it for their own end. Having regard to the comments that I have made and the patent anomalies which ought to have been realized and which would have been apparent to any careful legal practitioner, it seems to me that the practitioners have failed to give a proper attention and either made common cause with the case for their client and lost independence to act in the professional manner. Alternatively, they have failed to act in the professional manner in the best interest of their client, Mr. Leonard Modise. And it is on this basis that I direct that a copy of this judgment should be referred to the LPC for investigation of the practitioner's consent. The attorney and the counsel whose names have been withheld at the foot of this judgment should be provided or made available by the respondent or his counsel to the LPC. With regards to the issue of costs, Mr. Epstein argued that the recusal application is vexatious and submitted that the application be dismissed with costs against the applicant on the attorney and client scale or on the attorney and client basis, including the cost of 3 counsels. As a rule, the cost should follow the order. In the circumstances, the following order is made. The application for recusal is dismissed. Number 2, the applicant is ordered to pay the cost of this application on an attorney and client scale, and such costs shall include the cost of 3 counsels. That is the order. I had previously promised that today I will be giving all the documents that have been requested, and I will do so immediately when I get out. So just give us 30 minutes. and all the parties who needed to have the judgments. This judgment, the judgment for leave to appeal, and the reasons that were in relation to Rule 37A, including their own orders, will be made available today.
Lady, I inquire what the next step is in continuing with the trial. Obviously, we cannot go on today, but we would ask the lady, in light of the history of the matter which the lady has recorded, that subject to the lady's availability, that a date be set sometime in perhaps the second term, maybe the third term, for the continuation of the trial. If it should be argued, the lady, by my learned friends, that there are leave to appeals which they wish to bring, then that should not prevent the date being set and the trial proceeding. I don't know what their attitude is towards obtaining another date, but if they are going to argue that no date should be set pending potential appeals they may wish to bring, then I would ask the lady the opportunity to address you fully on that.
My lady, I certainly wouldn't have made those submissions. My lady, the simple position is we haven't been notified, we haven't been given, we haven't canvassed with our client and our witnesses when they'd be available. So we agree, we can set a trial date, but unfortunately we don't set any dates that we can give us availability because we have no notice.
All right, I'm available this week, I'm available next week. If all the parties are available, alternatively, we'll have to make a special arrangements.
And then may
All that I have to do is just to ask. Yes.
The next week I think is going to be impossible. I think
Yes,
certainly
it's
on
short
our
notice,
side.
yes.
May we inquire from the lady as to dates in the second term, and then we can liaise with our learned friends and see what dates fall within the parameters when your ladyship is available.
Next term I'm doing criminal for the whole term, unfortunately. But as I said, arrangements are always made.
Can we attempt to make arrangements then in the third term, a lady and your virgin lady?
Third term? Did you say the third term?
Or is my lady busy in the second term doing criminal matter?
Yes, I'll be doing criminal for the whole term.
Well, then we would ask if we can arrange a date in the third term.
Yes, you are free to choose a date.
May we do that and then...
And then I will just put it in my diary and then notify the JP.
Thank you.
My lady, if I may address the court. As you know, my lady, I represent the NPC who has brought the joinder application. The timelines for filing answering affidavits for the joinder application has passed. However, the parties are in communication with one another, and we initially intended to meet today to see whether the rest of the parties still intend on opposing the joinder application or not. Now, my lady, pertaining to specific dates, I've got no instructions on that. What I do, however, have instructions on, and this is not to formally address my lady on it, just to sort of from a practical point of view, and that is that my instructions are that my client will object to my lady sitting on the bench because my lady was the judge for the case management. Now, whether they are entitled to do so or not, or whether my lady has ruled on it or not, like I said before, my lady, this is not the forum for doing that. I just, from a practical point of view, wanted to inform my lady.
Anyone wishes to say something?
The current parties to the matter will engage to arrange a date in the third term, and if the NPC wants to intervene, if we can't come to any arrangement with them, then they must bring whatever applications they want in the meantime. But we cannot stop the continuation of the trial because they want to bring an application to intervene. We may be able to agree with them in terms of their intervention and joining or consolidating. If we can't do that, they will have to bring whatever applications they need to do in order to intervene. But the current parties, my lady, will be in a position to arrange dates And in the third term, I believe that to then revert to the lady about those dates, and the NPC will either fit in with those dates or do whatever they want to do to stop the trial progressing.
All right, let us do this. With regards to the date on the third term, all of you can just decide on the date and then just let me know which date I'm available. Then I will just go and ask for that to be given the space.
And really, are we looking, we'll certainly need 3 weeks. Could we, maybe because of the intervention, if it happens, can we set aside 4 weeks for maybe? Can we revert with a 4-week period?
The third term starts on the 17th of July. Unfortunately, during recess,
17th July.
I'll be busy with criminals, part heads. So we can only do it during term, which will work.
Yes, at the start of the third term, it starts from the 17th of July.
Yes, it starts from the 17th of
Yes.
July and ends on the 15th of September.
Yes, sometime in that period.
But you still have to agree with Mr. Vivian, and Mr. Mangolele is not here, so it's going to be a problem. Let us do this, it's not a problem. Just discuss among yourselves, and then when you are ready, then you can tell me, and then I'll put it in my diary
Thank you.
when it suits everybody else. And then as for the other application, I don't know what you intend to do. We can do that during Teams, anytime, any day, when all of you are ready. Yes, all the parties are ready. We can do that via Teams because I want to assume that it's going to take 1 day.
Yes, that'll be a one-day matter.
Yes, so that can be arranged, it's not a problem. Even if it's during the day, I will have to stop whatever I'm doing and then I can, 1 day it's not going to kill anybody. So I'll make a plan.
That's the good business.
All right.
Melanie, just 2 notes, but I'll discuss with my own friend, but I just checked my diary. I had started a 3-week trial on 17 June in Johannesburg.
Yes.
So we'll have to work around.
So
July,
if
not
we, if
June, 17 July.
17 July.
Yes. So that's the first day of term, as I understand it.
Yes, that's the first day of term, so it's going to be, you said 3 weeks.
That's 3 weeks, let me just double check that.
So it's
Then
1,
ends
2,
on-
on the 4th of August.
Yes.
So we can take from the
Yeah.
17th.
It would have to be after that.
Yes. So the next available date then is the 7th. 7th, 1, 2, 3, 7th until 25 August.
The 24th of August is when I finish.
I beg your pardon?
My trial finishes on the 24th of August.
Oh, I thought you said 3 weeks.
Yes, I'm just looking at that, it makes no sense. Let me rather, I was
1,
told it's a
2,
3-week trial, but I'm looking at my
3,
diary.
4,
It
5,
starts it on the 17th of
6.
July. and runs
So
to
it's 6 weeks.
I doubt that, my lady. I don't see it as a 6-week trial. Let me rather liaise with Mr. Epstein.
Right, yeah, I think it's safer that way.
Because that doesn't.
Because that also includes, we shouldn't be forgetting Mr. Mangolele. So
Yes, I'm going to also make sure that.
yes.
And I understand he's.
So let's not choose the date now. Let's rather than be safe and then talk to Mr. Mangolele.
Thank you.
Thank you. Is that okay, Mr. Barker? All right. Thank you, Rajan.
We will wait for that. Eh?
Bele